Welcome to today's webinars on GDPR compliance, also mean contract, what you should know about Article 28 GDPR agreement, also called Data Processing Addenda. Today's, you're going to hear from Diletta de Cicco, an associate in the Brussels office of Meyer Brown and part of the cyber and data privacy practice at the firm, as well as from me, Charles Helleputte, a partner in the Brussels office of Meyer Brown, also a member of the global cyber and data privacy practice at the firm. The topic for today is technical and somewhat complex, but we will do our best to approach it in a pragmatic and simple way. We will go around three different topics. First, identify which contracts are relevant for GDPR compliance. Then we'll look at what are exactly in practice data processing agreements. And third, what you should be looking after when you negotiate or interact with counterparties in negotiating a data protection or that data processing agreement. But first, what type of contract are relevant? That means responding to three different questions. You need to have a relationship involving the processing of personal data, and we will see in a second what this is all about. Happening between controllers, joint controllers, or processor, and we will also cover some of that today. Even if the key focus is on Article 28, and without spoiling what we will be discussing later on, that means for our end, for the main topic of today, an agreement between a controller and a processor. So the first question you should ask yourself is whether or not you are dealing with personal data, and look for personal data in agreement you have with other parties. Personal data is any information relating to an identified or identifiable natural person, and that receives a broad definition under GDPR. We speak, of course, about obvious personal data such as name and first name, but also much more complicated ones such as location data, IP addresses, and the like. So you know that you are dealing with this personal data. The tricky parts begin. And Diletta, tell us what is the question you need to ask yourself next.
So, who are you? Unfortunately, this is not a philosophical question under the GDPR, but still it's a question you will need to ask yourself every time you are dealing with personal data. There are two main roles under the General Data Protection Regulation, and those are controllers and processors. And it is crucial to know the role you are playing every time you are processing personal data, because then from your role you can actually derive obligations under the GDPR, and you can identify and assess what your requirements will be and how you are going to comply with the regulation. So let's see what are the different roles under the General Data Protection Regulation, and how you as an organization can actually assess and document who you are and what role you are playing with regard to personal data. Whether you are a controller or a processor depends on a number of issues. But the main question you should ask yourself is, who determines the purposes for which personal data are collected and the means of processing? The organization that has what we call decision-making power with regard to the processing of personal data, so the organization that actually has a real impact, a real influence in making a choice with regard to, for example, what kind of personal data are collected, how they are going to be used, whether they will be transferred to other organizations, is going to be the data controller under the General Data Protection Regulation. There are also some cases where if you are the controller, you won't be the only one. So every time you share this decision-making power with another organization, you will be called joint controller. And under the GDPR, specific responsibilities will apply to your organization and the organization that share this joint controllership with you. We won't look in details into this kind of scenario today, but for instance, this may be the case where you partner with another organization to organize an event, and you both decides how to run the registration process, what type of data you will ask to individuals, what kind of communication you will send out, who is going to be the service provider for running the registration process. As we said before, the second essential role under the GDPR is the one of data processor. Data processors are the organization that process personal data on behalf of another organization and under the instructions of a data controller. This means that your organization will play the role of processor every time you won't be the one who actually decides what to do with the data, but you will do that on behalf of another organization that rely on you, that relies on your services to run its own activities. The last role to consider under the GDPR is then the role of sub-processor. The role of sub-processor comes up when a processor decides to rely again on another organization. So every time an organization that plays the role of processor relies on another organization, instructs another organization to process personal data, this organization will be called sub-processor and will have the same responsibilities that are very similar to the one of a processor. So the next step is considering what is the impact of your role and what is the impact of the role played by the organization you work with on the contractual settings. So what do you need to put in place in the different scenario to ensure that the processing of personal data and the sharing of personal data with other organizations you work with is in line with the requirements of the GDPR? There are four main scenarios that you should consider when processing personal data. You may be in a controller-to-controller relationship, in a joint controller relationship, and we already described what this means, in a controller-to-processor relationship, and this is the kind of relationship we will focus on today. And then you can also be in a processor-to-sub-processor scenario, and this kind of relationship with a third party is very similar to the controller-to-processor scenario. If you are a controller or on your own, and you share personal data with another organization, but you each decides how to use personal data. So you don't share influence, you don't share the decision-making power on the way personal data are processed. You are likely to be in a controller-to-controller scenario. In this case, it is not mandatory to have something in place, to have clauses in place under the GDPR. But however, it is recommended to try to write down the responsibility of both parties, or at least to specify in the agreement you have with the other third parties that you both play the role of controller and that each organization actually decides how to deal with personal data, and this is mainly to avoid, for instance, the fact that you may be considered joint controllers. Joint controllers then, as we said before, share personal data and share responsibilities with regard to personal data, and they are required under Article 26, paragraph 1st of the GDPR to actually detail in a transparent manner what are their responsibilities. And this is usually done in what we call joint controllers agreements. So in an agreement that includes clauses, the purpose of which is mainly identify which of the parties is going to deal with the obligation of the GDPR. For instance, which organization is going to reply to a request from a data subject, or which organization is going to carry out a data protection impact assessment if this is needed, and so on. As I said, the kind of agreement we will focus on today are the one between a controller and a processor. Those are required under Article 28 of the GDPR that mandate organizations to have a contract or another legal act in place to actually deal with the way personal data are going to be processed by a processor, and it's actually also the document where the instruction from the controller to the processor can be found. And we will see later on in the course of the webinar what type of clauses the Article 28 asks organization to put in place. A similar type of agreement will also be needed to put in place between a processor and a sub-processor. This kind of agreement usually mirror the clauses that you can find in a controller to processor agreement. So let's look now at practical examples of controller to processor relationship. It is not always easy to understand who is the controller and who is the processor in a commercial relationship. There are some obvious examples, like the one listed in this slide. For instance, when you rely on an email software provider, you likely play the role of controller, and the email software provider plays the role of processor. Or you can identify a processor in the third party that manage your events. So each time your organization rely on a third party to run the registration process for your events, it is likely that the third party will play the role of processor. The same applies, for example, to the CRM provider, so the organization that manage the database for your organization. Apart from those obvious examples, there are, of course, some gray area where negotiation may actually long last, and negotiation and discussions around role of the parties actually constitutes the first essential step of negotiating what we call the data protection agreement or data protection addendum. In these slides, you can actually see a list of criteria you may consider when you process personal data, when you rely on a third party to process personal data, and that can actually guide you in understanding what is the role of the parties and derive then the contractual steps that need to be taken into account. Of course, these assessments need to be carried out on a case-by-case basis, actually assessing what is the actual influence that a party may play in the data processing of the personal data. And as always, under the GDPR, when you conduct an assessment, when you take a position, when you take a stance with regard to your compliance obligation, you will need to document them, so to keep records, to keep track of your reasoning behind it, and to be able to demonstrate your accountability. So what does a data protection addendum look like? You will find data protection addendum, of course, in written form. They are usually included in a separate addendum. So after the entry into force of the GDPR, it is likely that you were asked by your service provider to sign the new GDPR terms or the new GDPR agreements or the new GDPR addendum that was added to the main commercial terms. So, for example, to the MSA. What is the reason behind it? It is, of course, recommended to include data processing agreements in an addendum in order not to have to renegotiate all the commercial terms every time you need to deal with with privacy obligation, and with your privacy relationship with the third party. What you need to keep in mind when you deal with data protection agreements, data processing agreements as well, is that they do not deal with transfer of personal data. So there is a new element of complexity every time your processor is based outside of the European Union, and you will have to deal with it on a separate basis, trying to identify what is the legal transfer mechanism that you will put in place. And in some cases, they are also attached to the data processing agreements you have in place. So, for example, if we talk about standard contractual clauses, they will you will find them usually attached to your data processing agreements, but you shouldn't confuse them with what are the main terms that are the ones required under Article 28. So as I said, Article 28 of GDPR requires organizations to have certain clauses in place when they are in a controller to processor relationship, and also require organizations to include some details in the data processing agreement. As a general rule, when drafting data processing agreements or when negotiating data processing agreements, you should try to be as detailed as possible. For instance, as to what type of processing is covered by the agreement. The slides list the details that should be included in the agreement, and they relate, for instance, to the subject matter. So, for instance, you should specify whether the processor is dealing with personal data on your behalf for HR purposes, to keep your database, for intranet purposes, to run the registration for your events, etc. You are also required to include some details about the duration of the processing. So, for instance, whether the duration is the same one as the relationship you have with the processor, so that will end when the main contracts end. What is the nature and purpose of the processing? What type of data that organization is processing on your behalf, whether they relate to people that should join your fundraising campaigns, whether they relate to your employees, whether they include data that you gather through your stakeholder mapping, and so on. So this slide and the next one provide you with an overview of the type of requirements that should be imposed on a processor based on Article 28 GDPR. Indeed, the article lists a series of clauses, a series of requirements for processor that should be included in your agreements. We will then look in details into some of those, and we will also provide you examples of what negotiating this type of clauses may mean in practice. But this is those are the main obligations that Article 28 requires you to put in place. Here there is a second set of clauses that a data processing agreement should include, and we will now look into practical steps of dealing with data processing agreements.
And as you gathered from the long list that was included in the previous slides, maybe the first practical step is whether or not you should reinvent the wheel, or whether you can capitalize on templates that are out there. There are good news and bad news. So good news is that indeed a couple of national supervisory authorities have been working and trying hard to provide you with templates that will give you at least a basis to start drafting and negotiating your DPAs. You could also even hope that more are going to come, because in some of the work that data protection authorities in Europe are doing, or in some of the work that organizations themselves will be doing, such as code of conduct, for example, one could expect that template DPAs will also be developed. One of those available templates is one that was published by the Danish DPA. And just to be clear, it's not that we endorse that specific template, or that we suggest that you blindly endorse and take a look at him, but it's probably relevant and interesting to look at the different sections that it contains, just to see how it fits with some of the information that Diletta already provided and communicated to you. You will see, for example, if you manage to look at the table of content, that is probably written in small character, but you will be able to see that you have sections, for example, on transfer of data. As we discussed, transfer of data, it's not really something that is per se required and necessary to comply strictly with Article 28, but as very often processing activities entails or also include the transfer of personal data, the views that has been taken by the Danish data protection authorities is to provide a template that deals both with Article 28 requirements and also with the requirements and the justification of transfer under GDPR. You will also see, if you look, for example, at section 13, that it contains a section titled, so the parties' agreement on other terms. And frankly, you may wonder what those terms would actually be. It's something that we don't really recommend you going into, because really the idea of an Article 28 DPA is to try, as Diletta mentioned, to only deal with privacy and not to confuse, let's say, or to mix those discussions with other commercial relationships you might have with those contracting parties. Okay, so now you know everything about DPAs, or kind of. You know that it has to include a certain type of provision. You even have eventually used the Danish DPA template and start to adapt it to your realities. And you are waiting for your first DPA negotiation with a processor. Don't be surprised if you might just trash your DPA template straight away, especially if you are contracting with processors that have more bargaining power than you. And you will see there are a lot out there, especially when they are big and they are really dealing with a high level or high number of counterparties. Very often, the only thing that you might need to do is just tick on a box to accept preset DPA terms that have been drafted by your processor, or even worse, a processor not asking you anything and just telling you by the simple fact that you are using the services that you have accepted or signed up to a data processing addendum that they developed. Mailchimp is an example of those ones. Don't be too shy though, because we experience a DPA negotiation where confronted with what looks like a no decision scenario, so that you just have to take it or leave it. By the time that you voice some concern, you might receive an update version of the DPA back that sometimes is more acceptable or contains less processor-friendly terms. But irrespective of whether or not you will come with your own DPA template, or even if you will be pushed with a DPA prepared by your counterparty with no bargaining power at all on your end, really the idea for the couple of slides we're going to go through now is to make you realizing or identifying the clause that you probably need to look at, just even to know what kind of obligation or interaction you are agreeing to. And we'll list 7 of them, such as the role of the parties, the assistance obligation of the processor, some clause dealing with sub-processor, the question of the deletion of data, audit rights, liability cap, and transfer. And we will start straight with the role of the parties, and I hand over to Diletta for that.
So based on our experience, the first thing that may cause confusion in a data processing agreement, and also most likely one of the first aspects that is the basis of negotiation relates to the role of the parties. So what is your role under the agreement you are signing? As a general rule, when negotiating data processing agreements and drafting data processing agreements, you should try to be as clear as possible as to what role you are playing and the role played by the other party to the agreement. With this regard, we have seen cases where clauses weren't detailed enough, where it wasn't clear which one of the party was actually playing the role of controller and who was playing the role of processor, and these kind of clauses may actually lead to unpleasant discussions when, for example, you will need to deal with a data breach, where you will need to deal with a request from a data subject or from a request from a data protection authorities. What you should avoid when negotiating around your role in the data processing agreements are, of course, mixed qualification cases, so cases where it is unclear who is playing which role. You should also avoid generic language, so vague language vague clauses that list the obligation of controllers, that then list the obligation of processor, but that actually doesn't identify who is going to play which role. And you actually should also try to avoid clauses where processors aren't required to do what they need to under the General Data Protection Regulation. In these cases, we, of course, recommend you to try to resist to this kind of agreement, although, as Charles discussed, it may be hard, depending of the negotiating power you have. But in any case, understanding the role of the parties constitutes the basis of the data processing agreement, so this should be on the top of your list of topics to be remediated when negotiating an agreement. Another type of clauses that may get complex or problematic under the negotiation of a data processing agreements relates, of course, to the assistance obligation of the processor. If you are a controller under data processing agreement, you are expected to take actions and to be responsible when, for example, something happened, or to be responsible with regard to the data processor you are relying to. And when you need to take action under the GDPR, in many cases, you need to do that within certain deadlines. This is why it is essential that you trust your processor. It is essential that your processor provide assistance to you, but not only provide assistance, but that they provide it in a specific way, in a detailed way, and in a way that actually is of help to you. If we think, for example, of data breaches, these are one areas where assistance from data processor is essential. And why? Because in many cases, the data processor will actually be the organization that has real control over the personal data, that knows, for example, if the data breach happened and why, that should actually inform you on what kind of measures were taken, and all this information will actually help you communicate with data protection authorities, because the complexity here is based on the fact that many times the processor is going to be the organization that has the information, but you, the controller, will be the responsible one for communicating with data subjects and also data protection authorities. So when you need to rely on your data processors, what you need to avoid in your data processing agreement? You can't accept clauses that are general and vague about the way the processor will assist you. You can't accept general assistance, but you need to know the details on of how the processor will assist you. And these usually include what type of assistance will be provided, whether, for example, they will communicate to you, under which deadlines they will do that, how they will assist you, what type of information will be provided. As I said, specific attention in this scenario should be paid to the case of data breaches, mainly because they lead to high responsibilities vis-a-vis data subjects, vis-a-vis data protection authorities, and also they may, of course, lead to high financial penalties and reputational damages. This is why you will need clauses that are specific, as I said. Sometimes when you think of deadlines to impose to your processor, you should also keep in mind that, for instance, when we talk about data breaches, too short deadlines may not be of help either, because you will need to avoid false positives. So, for example, in these cases, you will need to provide the processor with enough time, with adequate time to actually investigate what happened, to investigate the data breach, and actually take measure and understand what happened before relying you the information that you will then communicate to data protection authorities. So when you are a controller under the GDPR, you are required to conduct due diligence on the subprocessors used by your processor. This is an essential step of your GDPR compliance, and actually require organizations that plays the role of controller to review who are the subprocessors, to be able to see what is in place, what kind of clauses are in place between processor and subprocessor, and to also object to the use of certain subprocessor. This is why when negotiating data processing agreements, you should avoid general language around the fact that you as a controller authorize any subprocessor, so the appointment or any subprocessor, or the fact that, for example, you as a controller may not object. But for instance, if you do not agree on the use of a subprocessor, you are actually forced to terminate the agreement with that processor. So as I said, try to be as detailed as possible. Try to look at the list of subprocessors that should actually be provided, and this is done mainly in an appendix to the data processing agreements, or with a link to a website where you will be actually able to review who these organizations are and whether you can actually trust them from a privacy perspective. Let's now see what are the other aspects that may cause long-lasting negotiation around data processing agreements, and I hand over for this to Charles.
So another interesting debate very often lasts on the deletion of the data. As you know, or as you get from some of the things we have been discussing so far, one of the key things around privacy is to make sure that you don't keep data for too long, let's say, or too long as necessary. That also has some translation in your relationship with your processor. By the time the agreement terminates, there is probably no reason for the processor to keep the data that he was processing on your behalf. However, if what happens is just a mere deletion of the data in the end of the agreement, but that, bad luck for you, the processor was the one having all of the data and you had not even a copy, by the time everything is deleted, you will probably be facing with some difficulties in trying to retrieve data you don't have. That's why by the time you negotiate your data processing addendum, you need to define what will happen at the end of the relationship, and whether or not you will, for example, just ask the processor to delete the data, or you will first ask him to return the data that he is processing on your behalf. You should also keep in mind that even if you require the deletion of the data, and even if you are justified in asking the deletion of the data, it's not always technically feasible to just have data disappearing. People have dealt with those kind of requirements in a pragmatic way very often, and will, for example, agree to put data beyond use. So to do their best to delete the data, but if they cannot delete the data, for example, commit to have them in a place where they are not easily accessible or hard to process for a large number of people within the organization. Those are tough calls to make, but sometimes it's something that you will need to consider and balance both your requirements under Article 28 and the technical constraint associated to some of those requirements. As Diletta alluded to when she discussed the need to review subprocessor terms and conditions or processing addendum, it's very important that your DPA include clear audit rights for the controller. And why is this so relevant? Typically because it's the responsibility of the controller to review and carefully assess the preparedness and compliance of the counterparties is using and relying on. And if things goes wrong, the one that will be liable is probably you as controller in first instance, even if eventually you might be able to claim some liabilities of your processor vis-a-vis the data subject and the authorities. You will be the one liable. That requires you to really resist all of those clauses that will impede you to audit your processor. And you should really try, for example, not to take for granted undertakings of processor that will confirm or assess their compliance themselves, or even providing some certificate on a yearly basis of some third parties. You better exercise all of those audit rights yourself or by one of a third party you trust, rather than relying on the self-assessment of the processor you are using that they are GDPR compliant. As we mentioned already, DPAs very often are also an opportunity or a try, let's say, by a processor, especially if they have some bargaining power, to introduce some liability caps. This is something we saw, of course, very often for processor-friendly drafted DPAs that will typically include clauses seeking to limit their liability for breaching the DPA or even breaching EU data protection laws. You should really resist signing up to those clauses, and you can probably resist them by just telling your counterparty that those liability caps, have nothing to do with DPAs, but should just follow the rules and the principle of the main commercial agreement, rather than being stuck in a privacy type of discussion. And finally, one word on a transfer mechanism. When the processor is located outside of the European Economic Area, very often the DPA may include some reference to transfer mechanism in the form of standard contractual clauses. As we discussed already, don't be confused, let's say. It's important to deal and have a proper mechanism in place to deal with transfers, but transfers discussion should be separate from the strict Article 28 compliance. If you receive a DPA that includes standard contractual clauses, just ask yourself the question, is this specific way of dealing with transfers the right one? And if it's the case, please also take some time to review both the DPA and the standard contractual clauses, because what for sure needs to happen is to have some adequacy between, for example, the processing activities that are described in the DPA and the one that you find in the SCCs. You also need to review the SCCs to make sure that they are accurate, that they are the right one, because the various forms of standard contractual exist, and also that those standard contractual clauses haven't been modified, because if they are or they were modified, then you might otherwise not rely on them, or at least they might not prove to be a valid mechanism for assessing transfers. So that was a little tour of the various settings or formalities of Article 28 agreement. Know what? If you haven't done anything yet to start, let's say, your remediation with vendors, it's probably more than time to go and do something. And we suggest you a 6 steps process. The first one that is really relevant for you, not only for a contractual remediation or discussion, but just to realize what you are doing with data and what are your compliance requirements more broadly with GDPR, is to make sure that you undertake what we call a mapping of the personal data your organization is processing. And that really means looking at instances where you are collecting or processing personal data and why they are used for. That's step 1. Then you need to decide your role under the General Data Protection Regulation. So whether or not you are a controller, eventually a joint controller, a processor or a sub-processor, all of those terms that you are now perfectly familiar with. You need to do and conduct the same assessment with your counterparty by the time we are speaking about commercial relationship with personal data to assess then what kind of contract you need and benchmark that requirement against what you have eventually already in place. If what you have in place is not in the format or in the settings of what we discussed today, you probably need to eventually renegotiate your agreement or try to do so. It's not an easy journey, but it's something that is absolutely necessary if you want to mitigate your risk under the regulation, and also show that you have taken steps for compliance. Compliance with GDPR is truly a journey, and by the time you have done all of that, you cannot just rest and pause, but you will need to review your contract on a periodical basis to make sure that they are still accurate and that they reflect, for example, the processing activities that you are undertaking. It's a never-ending but fascinating journey. This closes today's session. We hope you find it useful. Should you have questions, do not hesitate to contact either Diletta or me, and you have our details here in the slide.